Most people think a contested divorce in India takes a year or two. It doesn't. 6 to 8 years is common in busy family courts, and almost nobody tells you that going in. There are really only two doors into divorce under the Hindu Marriage Act, 1955. Mutual consent, under Section 13B where both spouses agree. Or a contested petition, under Section 13, where one side alleges cruelty, desertion, or adultery and the other side fights it. Which door you walk through decides almost everything that follows, the cost, the timeline, even how bitter it gets. Mutual consent starts with both spouses filing a joint petition in family court, along with a settlement on alimony, custody, and property. The court then asks for two motions, 6 months apart, called the cooling-off period. Some family courts, like those in Delhi and Mumbai, will waive that 6 months if there's no chance of reconciliation, following a 2017 Supreme Court ruling. Others insist on it regardless. It depends heavily on the judge. Realistic cost for mutual consent, if both sides genuinely agree and don't fight over property, often somewhere between 30,000 rupees and 1.5 lakh rupees in lawyer fees, depending on the city and how complicated the asset split is. That's the honest range. Anyone quoting you a fixed, guaranteed number before seeing your documents is usually padding the estimate. Contested divorce is a different world. One spouse files, the other is served notice, and if they don't agree, it becomes a full trial, written statements, evidence, cross-examination of witnesses, sometimes even private investigators. Grounds have to be proven, not just claimed. Cruelty under Section 13, 1, IA, covers physical and mental cruelty, but courts want specifics, dates, incidents, sometimes medical or police records, not vague unhappiness. Here's the part most people get wrong, they assume the court fight is the whole battle. It isn't. Interim maintenance applications under Section 24 and later permanent alimony often take longer to resolve than the divorce decree itself. I've seen cases where the divorce was granted in year 3, but the maintenance dispute dragged on for another 2 years afterward. Mediation is mandatory in most contested cases now. Under Section 89 of the Civil Procedure Code, the court refers you to a mediation center before the trial grinds forward. Honestly, mediation is underrated. Lawyers rarely push it hard because litigation pays their fees, but a genuinely willing couple can settle custody and property in mediation in a few sessions, saving years and lakhs of rupees. If domestic violence is part of the picture, that runs on a separate track entirely. A complaint under the Protection of Women from Domestic Violence Act, 2005, filed with police or a protection officer, or a call to the Women's Helpline 181. That process can move alongside a divorce case, but it is not the same filing, and conflating the two is one of the most common mistakes people make. Child custody, when there are kids involved, is decided on the child's welfare, not on which parent wins the divorce. Courts increasingly favor joint or shared custody arrangements over sole custody, especially once the child is old enough to express a preference, generally taken to be around 9 years old. So here's the single most useful thing to take from this. If there's any real chance both sides can agree, mutual consent under Section 13B is almost always faster, cheaper, and less damaging than a contested fight, even if it means swallowing some pride to get there. If you found this useful, subscribe. We break down one real piece of Indian law like this every week.